said, this is the January. Okay, welcome to the January membership meeting of the Cooperative and Condominium Advisory Council of the Building and Realty Institute. We have a very interesting topic tonight to discuss. The topic is subletting, what your board needs to know. We had a registration of 101 reservations as of 12:30 p.m. earlier today. So that means that this is obviously a topic of interest to both co-ops and to condos. At this point, I'd like to turn over the process to CCAC Chair Jane Curtis for a brief series of opening remarks.
Thank you, Jeff, and welcome everybody on this dreadfully cold evening. We appreciate you joining us, and it's wonderful to have such a good turnout. We've had many topics at our various membership meetings, but we were trying to recall if we had ever addressed the topic that we have tonight, and we decided that none of us could remember doing so. And it's one that is really important. Should you or should you not sublet? What are the considerations, the pros and cons? If you do decide to sublet, what precautions should you take? What processes should you set up? And so we have a panel of both legal advice and practical experience with this. And so with that, I'm just going to turn it back to Jeff to introduce our panelists.
Thank you, Jane. And it's good to see that you made it on. Absolutely good to see that. Here is the explanation of tonight's meeting format. Our main speaker will be Richard Klein, an attorney with Dorf, Nelson, and Zauderer. Richard will comprehensively address the topic of tonight's meeting. After Richard's presentation, we will have additional comments from Richard Filippi, who is a board member of Bronxville Lodge and a member of the board of directors of the CCAC. And we will also have some comments from Neelam Khattri, who is a member of the board of directors of Fountainhead Owners Corporation and a member of the board of the CCAC. It is now my pleasure to introduce Richard Klein. Richard Klein is a partner and co-chair of the Commercial Real Estate and Land Use Department of Dorf, Nelson, and Zauderer, a national law firm, and is a member of the Building and Realty Institute. Mr. Klein became a real estate attorney after having worked for several years in his family's real estate business, where he was involved in real estate management and overseeing leasing and sales of both commercial and residential properties. In November of 2020, during the COVID-19 pandemic, Mr. Klein started the firm of Klein, Greco, and Associates, which focused solely on real estate matters. The firm handled matters in both New York City and in Westchester County. A significant part of the firm's practice, which Mr. Klein maintains at Dorf, Nelson, and Zauderer, was serving as general counsel to boards of directors of cooperatives and condominiums. He has extensive experience in handling board meetings, amendments, contracts, and much more. He also frequently worked with commercial real estate developers in New York City and Westchester County in both the acquisition and sale of commercial properties. Mr. Klein is very active in the Building and Realty Institute. He attends many of our association's membership meetings. He has been a guest on the association's podcast series, Building Knowledge with the Building and Realty Institute. Once again, it is my pleasure to introduce attorney Richard Klein.
Wow, thanks, Jeff. I really appreciate that introduction. Makes me sound really impressive. Thank you so much, and thank you for having me here tonight. And same to Jane. Thanks for putting this program together. And I know Tim Foley and Mike Murphy couldn't make it tonight, but I also want to thank them for all the hard work that they do on BRI. It's really important. So we're talking about subletting tonight, and yeah, I'm going to assume that there's a certain amount of knowledge that maybe you don't have. So if I sound like I'm going to basics, please excuse me, but I just want to make sure everyone understands what we're talking about. So the first thing I'm going to talk about is just the difference between a co-op and a condo. So with a condominium, that's considered you're buying real estate, so that when you own the unit, you get a deed that gets recorded with Westchester County. If you get financing from a bank, you're getting a mortgage that also gets recorded with the county, and you're the owner of that unit. So really, if you want to have somebody living there, technically the term wouldn't be a sublet because you're the owner and you're leasing it out to somebody, but just everyone calls it a sublet anyway, so we'll just keep it at that. And with a co-op, when you buy a co-op apartment, technically you're not buying the actual apartment. You're buying shares of stock in a corporation, and those shares allow you to live in a particular apartment, and you sign what's called a proprietary lease. So it's sort of like a landlord-tenant relationship where the co-op is the landlord, and you as the shareholder, you're a tenant. And if you decide that you want to rent out your unit because you're already the tenant, that would be considered like a sublet because you're leasing it to what would be called a subtenant. So that's just the two basics about co-ops and condos. And subletting, like I said, it's you own the unit or you're the shareholder of the unit, and you're going to lease it out to somebody else. So do we allow subletting or do we not allow subletting? And this is general to both co-ops and condos. A lot of the buildings that I represent, some of them have an absolute ban on subletting. They just don't allow it. Well, that's more in terms of co-ops. Why might they have that sort of ban? Well, first of all, for a co-op board, if you say no sublets at all, it's just easy to enforce, and your decision is sort of a given. You don't have to make those decisions in certain gray areas, which we'll get into in a little bit. Not only is it easier to enforce, but some buildings don't like to have sublets because they think it's a security concern. They're very concerned about knowing who's living in the building, and not, they're concerned about other people subletting, coming in and out, having, bringing in guests. So it's easier to track who's supposed to be in the building, perhaps, if you don't allow subletting. A lot of boards also feel that when a tenant lives in the apartment, they don't have the same stake as an owner of the apartment, in the apartment or in the building. So they may not, maybe they're not as careful about putting out garbage or, making noise or, all those quality of life issues. They feel that an owner or a shareholder has more at stake in the building, so that they don't want to allow subletting. Also, they just don't want that hotel vibe. They don't want to feel like people are coming in and out. They want to feel that, the people living there are going to participate in the governance of the building, show up at annual meetings, and just get involved in whatever's going on in the building. And then for a co-op, there's also some concerns about being able to finance, whether it's financing a loan when you're buying a particular apartment, or even the co-op getting its underlying mortgage. Fannie Mae has certain restrictions that they look at in terms of the co-op, and one of those is occupancy, owner occupancy. So if you have a lot of sublets in the building, it could make it difficult for a co-op to get its underlying mortgage, or for a purchaser to get an end loan. So that's why some buildings might say, no, we're not doing any subletting at all. That's the rule. But why would some buildings allow sublets? Well, one of it is just because we're human and things come up in our lives, and you might buy an apartment and, maybe you're single or you're newly married or whatever, and, you get married or you have children, your needs change, your need for space changes, or maybe you have a job and, you get relocated to California, or maybe you have health issues and you need to move back in with family, or you're elderly and you need to go into assisted living. And when those life events come up, maybe the market isn't such that you want to sell because maybe it's a down market and the price that you can get is less than what you paid for it, or you just want to hold on to it for a little while. Maybe, things will change and you'll be able to come back. Like if you have a job relocation, maybe it's for a short period of time, but you'll be coming back. So I think some boards recognize that, these human events happen, and so they allow subletting and they try to work with those individuals to accommodate when those things come up. Of course, that's different, in terms of investors, buying units, and, that's a different kind of outlook, and boards might look at that differently. But in terms of the human aspect, I think a lot of boards realize that there are certain hardship situations that come up that might require someone to be able to sublet. So first, let's talk about subletting in co-ops. And if they do allow sublets, what are some of the things that they should be looking at? What are some of the restrictions or requirements that they should be thinking about if they're going to allow sublets? Because in the co-op situation, the boards have tremendous control over what goes on. And one of the first things that any board contemplating subletting should be thinking about is talking to their professionals, particularly their attorney, and reviewing their operative documents, such as the bylaws, but particularly the proprietary lease, which I had mentioned earlier, because the proprietary lease touches on subletting and what the board can require for subletting. And as we discuss some of these things, you need to make sure that your lease has the appropriate language to give the board the power to set certain policies when it comes to subletting. So, for example, one of the requirements that a board could impose is a residency requirement. Now, typically, I would tell my boards that that doesn't necessarily need to be in the lease, that kind of a requirement. That could just be part of your sublet policy. But they might say that you have to live there for 1 year, or you have to live there for 2 years before you can approach the board and do a sublet. Why might a board want that? Again, if someone's buying the unit and is subletting it right away, that might just be some investor who's looking to make some money and not really be involved with the building. So boards want to know that when you buy the unit, hopefully that's not your intention, and that you're going to live there for a while. And if you have one of those one of those situations that I mentioned earlier come up, then maybe they'll contemplate the sublet, but they want to know that you live there for a couple of years, or whatever they might do. It could be 1 year, 2 year, 3 years, whatever a board decides as a residency requirement. They also may allow subletting only for a particular period of time. So they might say you can only do a sublet for 1 year, or maybe it's for 2 years, or maybe it's for 2 years in a 5-year period. So every time 5 years passes, you could do it again for 1 or 2 years. So these are different things that they look at, because they're trying to say, all right, so if you have a hardship, we'll give you a year, maybe we'll give you 2 years. But, at some point you have to deal with it. And if you're not coming back, then you maybe have to make an effort to sell the apartment. So these residency requirements and time periods are ways of controlling it, even though you want to help out somebody who's dealing with a hardship situation. And just, in terms of the investor, I always like to tell people, a lot of co-op boards don't want people buying it for investment purposes. And I know, as a side comment, a lot of my buildings, the co-ops are always talking about a flip tax and trying to get a flip tax written into the lease so that they can charge a fee when someone sells an apartment. And the term flip tax really got started because back in the day, co-op boards were trying to keep investors out. So they figured if you're going to come in and sell your apartment right away, you're flipping it. So this would be a flip tax to try to discourage flipping. So that's just a little aside. But anyway, so those are, one thing that they can do is the residency requirement. And I'm going to mention too, I know we have Neelam and Filippi up on the screen here. I want to remind them that please feel free, if you have any comments or anything to say as I'm going along here, please feel free to interject.
Yeah, that's thank you, Rich. Yeah, our co-op has guidelines. I think all co-ops should have guidelines for what they want to do. But we actually have a requirement that you have to own the apartment for 3 years prior to any renting before you approach us, the board for. And the first thing is we ask for approval from the shareholders lender, because we want to make sure that they're on board with this, because it's their investment as well, because they got a mortgage on the apartment. We do allow for up to 3 years, but it's 1 year and no automatic renewals. So it's only 1 year at a time, and then you have to go apply again. There's a sublet fee of 1 month's maintenance to the corporation for each year of the rental. So, and hopefully the best is to have the fee go into the reserve fund. We also have a interview, request of financial information, and an interview of the renter by the board, and the subletting is contingent upon the board approval, obviously.
Right.
So we have to have a say. And then we finally review the house rules with the renter, and we also request rental insurance. The reason we pick 3 years is that's usually the standard for an overseas visa. So if you're going to go, usually when somebody gets transferred, it's for a 3-year cycle. And then, of course, if there's non-compliance to the house rules, the board can demand the renter vacate the apartment. But as you said, for all sorts of for requirements like this or guidelines like this, seek the advice of an attorney, of your corporate lawyer.
Well, Richard, yeah, that was my whole presentation right there. So thank you. No, yeah, I mean, I was going to ask you how you got to the 3 years, and you made an excellent point. In fact, my buddy Ron Scher, who I know is on this Zoom, had texted me a little while ago. Not forget to mention that when a co-op signs off on a recognition agreement, and for those of you who don't know, when you're buying a co-op, if you get financing, the lender is going to ask the co-op and the purchaser, potential shareholders, to sign a recognition agreement where they're asking the co-op to recognize that the lender has an interest in this apartment, and if there's a default, that they have to let the lender know. So, for example, if the shareholder doesn't pay their maintenance, we let the lender know, and they typically step in, pay it, because they want to protect their collateral. And as Ron texted me a little while ago, don't forget to mention that the lender also has to consent to a sublet. So, Richard, that was a good point that you make. I'm sure most co-ops are not doing that because they don't. But that's a good point, and I'm glad to see that your board is on top of that. And so the 3 years, yeah, I mean, that's a good number. I mean, like I said, I see buildings do it for 1 year, 2 years. There's not really a rhyme or reason. It depends on the board. And that's what's always interesting to me, because you can have one board come in and this is their policy. And, I always tell when I do residential closings and I have someone buying into a co-op, I always say, I'll tell you what's going on, but this is the snapshot picture of right now, because in a year or two, there can be a new board and, they can make changes to some of these things. So you never know what's going to be. That's why most people, not most, but, people do prefer sometimes condos as opposed to boards.
So Richard, let me interject there if you don't
yes.
mind.
Not at all.
That's where my question was, like, in a co-op and you mentioned it, from board to board, these residency requirements and the duration of staying, all these can change from board to board. It's not consistent. It's not clear in the bylaws or the proprietary lease that it has to be followed a certain way.
Well, I mean, so the proprietary lease is extremely important, especially when you're talking about charging a sublet fee. So, for example, if you're doing a sublet, the managing agent can charge their administrative fees for processing the application. If I need to review something as the co-op's attorney, I get to charge my legal fee. But the language has to be very specific in the lease that the co-op can impose a sublet fee above and beyond those typical costs. So if they want to charge, like Richard's building said, I think you said 1 month of maintenance, or if they do a per share amount or something on, if there's a profit or whatever they come up with, the lease has to specifically give them the right to do that. Now, I'll counsel my clients not to put in the specific way they're going to do the charge, just that they have the power to do the charge. But typically, most leases won't address duration or residency and issues like that. That would be in the policy because it's at the discretion of the board. So a board could presumably change that, in a few years. But any current lease, would still continue. But any new leases going forward would be subject to those new rules.
Okay.
And Richard, the rights of a holder of unsold shares, don't want to step on your toes, who have the right to sublet without getting consent. So I'll put it back to you. You can answer that.
Well, that's Ron Scher. Thank everyone. That's my buddy Ron Scher. Great. Also a brilliant attorney when it comes to co-op condos. And I wasn't going to really get into the sponsor aspect of this, but yes, that's right. As most of you know, if there's a sponsor in the co-op or the holder of unsold shares, which means that the sponsor converted the building to a co-op, and maybe he was left with 10 or 15 units, let's say, and at some point he wants to get out, he or she wants to get out, and they sell it to somebody else. Every co-op proprietary lease that I've seen provides that if such a transaction takes place and that person who is the buyer, him or her or their family do not occupy the apartment, the unit is considered, a holder, the owner is considered a holder of unsold shares and maintains all the rights that a sponsor has. So they would not need board approval for a sublet or a transfer. So they can pretty much do what they want. And, sometimes that's an issue. I have a building in the city where the holder of unsold shares, has a significant number of units and he's subletting them. And, it's been an issue because there's no vetting at all of the subtenant. And a few of them have been a problem. It's an elevated building. They leave garbage in the elevator. They have dogs or pets, and the dogs are defecating in the hallway. And we go after him as the owner of the apartments, but it's nice to be able to vet the applicant if possible.
It's always an interesting issue, Richard, with regard to the roommate law and how that applies to a subtenant. Does the subtenant have the right to bring in other people without getting consent based upon the roommate law 235F? So I'll let you answer that, Richard.
Well, why don't you answer it, Ron, since you brought it up?
No,
you know the answer. You know the answer.
I spoke to you yesterday. I don't want to step on your toes.
It's okay. Why don't you give us the answer? Because it's not really where I was going with this outline. So
the roommate law supersedes, unfortunately, the rights of the board to interview, to approve, to do this. And it is an anomaly and it's a problem. Even with sponsors, I will say this to you. We like to demand a meet and a greet with either sponsor sales or with sponsor subtenants. These sponsor renters really have no regard for the apartment. They think they can get away with things without adhering to rules. But as far as I'm concerned, market rate tenants of sponsors do have a duty to adhere to the house rules, especially ones for security. When it comes to the roommate law, check with your attorney. Check with Richard. Richard's a great attorney. He will help you understand what it is that the roommate law does. It's really, there are many people who say it's really a roommate. It's a roommate masquerading as an improper sublet. It is a problem in this world. And if you have sponsors that are still holding on to apartments, ask Richard or Richard, the two Richards, regarding something called the Jennifer Realty case, trying to force sponsors to sell. Sponsors agreed.
All right, Ron.
I'll let it go. Thank you.
All right. If I could interrupt, once Richard and Neelam are done with their comments, we will have a complete question and answer session. We ask the meeting participants to please insert their questions into the chat box, and we'll go question by question. So now I'll turn it back to Richard Klein.
Thanks, Jeff. No, I mean, just picking up on a couple of comments. I think Richard and I both mentioned that, if there are problems, we try to go after the tenant or the owner of the apartment if there's an objectionable conduct, especially in a co-op. And in terms of these meet and greet meetings, I have some buildings that do that when it's a holder of unsold shares or the sponsor selling the subletting the apartment or even transfer. But that's a double-edged sword, because sometimes you do the meet and greet and you say, oh my God, look what's moving in, and you have no say. So it's you still have to let them in because the holder of unsold shares. But anyway, so we were talking about what some of the things that you need to look at. A lot of my buildings will limit the number of sublets that they allow. Partly that has to do, as I mentioned up front, about the Fannie Mae requirements, that they don't want to have a high percentage of sublet apartments in the co-op, because that could affect their ability to get an underlying mortgage or to have a purchaser get an end loan. So they'll try to figure out, typically around 15% you should be okay if they allow even that much. Some buildings will limit it to less. And what they'll do is that, once, if they are limiting the number and I'm subletting my apartment and then my sublet's done, they probably are not going to let me come back in a year to sublet it again, because maybe Rich Filippi wants to sublet his apartment, so they'll allow him to go at the next one because they're limiting how many apartments can be sublet. And as we spoke about a little while ago, the imposition of fees. As I mentioned, it's extremely important for the co-op to review their proprietary lease with their attorney and make sure that the board has the authority to impose those fees. Some buildings, put it into their bylaws. I think that helps, but I talk to when I counsel my buildings, I try to say, let's get it into the lease, because typically a lease, the proprietary lease, requires a shareholder vote, and it's a super majority, typically 2/3, sometimes 75%, but the shareholders have to vote for those amendments. Whereas in the bylaws, the board can do that on its own. And I feel if you can get the language into your lease from a supermajority of the shareholders, most courts are not going to, say that there's an issue. They're going to uphold that kind of language. So you want to make sure you're reviewing your documents with your attorney and that you have those rights in the proprietary lease. As Richard had also said about submitting an application, of course, the co-op board has the right to ask for an application and to review finances, feel comfortable that this person will be able to make the rental payments to the shareholder. I mean, it's important, but ultimately the shareholder is still on the hook for the maintenance payments, regardless of whether they're getting their rent or not. So you have some comfort in that, but still you want to make sure that they're financially capable, that they sign off on the house rules. You interview them to see who they are. And understand that if the shareholder defaults in the payment of maintenance, you also have the right to go after the subtenant to collect the rent that would be due to the shareholder. That could go to the co-op to help defray whatever arrears the shareholder is in. And up here in Westchester, if you're on the board, most of you are familiar with the Westchester County's Cooperative Housing Disclosure Law, where if there's an application to purchase, if it's rejected by the board, a form has to be filled out. It goes to the Human Rights Commission because they're trying to keep track to see if there's perhaps discrimination in some building. That law does not apply to sublets. So, you don't have to file any form with the Human Rights Commission if you reject an applicant for a sublet. But again, it still can't be based on some discriminatory reason, because that could subject you to a discrimination claim. So, in terms of making these rules, I know sometimes my boards will come to me and say, we have this particular situation. We want to accommodate this person. What do you think? Sometimes, depending on what's going on, we'll maybe try to work something out. But, it's tough because once you start, if you have your policies in place and then you start deviating for somebody, it's hard to say to the next person who will say to you, well, you did it for him or her. Why aren't you doing this for me? So I try to tell my boards, be consistent. Whatever your policies are, apply them uniformly, especially to people on the board, because I've seen situations where, someone feels they're on the board so they can sublet and jump the line or, do it a little not in accordance with their policies. And that's definitely not something that should be going on. should be the same for everybody. And that makes it easier to enforce. And that's pretty much the gist for co-ops. And like I said at the beginning, the board has a tremendous amount of authority to oversee what's going on. And as long as they're operating, pursuant to their operative documents, they should be okay. Condominiums are a different animal because you own the unit, and the way the operative documents, which are typically the bylaws and what's called the declaration of condominium, the way those documents are written, there's a lot of latitude for unit owners to both sell and sublet as they want. Typically, most of these documents will provide that the board has what's called a right to first refusal. So if you want to sublet your apartment, you submit an application, and if the board doesn't like that application, they can say no, and that's their right of refusal, but then they would have to sublet the apartment themselves on the same business terms as whatever you put forward to them. So most condominium boards don't want to be involved. They're not in the tenant business, the landlord tenant business, so they're not going to do that. So pretty much you have a lot of latitude in a condominium to sublet to whomever you want. And that's why a lot of my condominium clients find that their list of unit owners typically has a lot of investors, often very, especially in the city, Manhattan, foreign investors, because they're buying it as an investment and they're going to sublet it. And it becomes, an issue, the same issues that the co-op doesn't want, quality of life issues, people not feeling the same way about, how they treat the building. And having an annual meeting for a condo sometimes can, just doesn't happen because a majority of their unit owners are investors. They live overseas and they don't show up. I mean, even with the Zoom meeting now, it's hard to get a quorum for an annual meeting. And the board stays in place for year after year after year because there's just no elections and nothing can get done. And it's a problem. And I have actually a lot of my condominium boards coming to me now to see what can we do to amend our declaration and or our bylaws to function more like a co-op. We want to have more control over what's going on here. For example, I have some condominium boards where if someone's buying in a trust or a limited liability company, they want to impose restrictions so they can restrict who lives in that apartment, and who they're renting it to. And I'll do what I do. And some attorneys won't push back because they don't want to waste the time. They just want to get the deal done. But other attorneys will push back and say, Rich, you don't have the right under the declaration or the bylaws to do that. And they're absolutely right. So a lot of the condominiums are trying to now change it a little bit to get some co-op rules, and so that they can have more control over who can sublet an apartment. And like a co-op, they're able to, the managing agent collect their administrative fees. If I have to do some work, I can get my legal fees. For both co-ops and condos, there's move in and move out fees. But unless the declaration provides for some sort of transfer fee, the condominium would not have a right to, a sublet fee, to impose any additional fees on a sublet unless it's in their documents. So those are really, the differences between the co-op and condo, and one is more restrictive than the other. Like Richard mentioned up front, a big issue is when you have a tenant in a sublet and they're causing a problem and they're objectionable, or they're not paying attention to the house rules or the rules and regulations. The co-op has remedies. They can go after the owner for and use objectionable conduct and other things to get it straightened out. It's a little more difficult in the condo. You have to say it's a nuisance, or it's a little harder to go after the unit owner. So you have to pay attention to that. And I also find, especially in co-ops, you need to be communicating with your property manager and keeping track of the end dates of these subleases to make sure that when the lease ends, that tenant's moving out and the shareholder either is moving back in or, the apartment's vacant, but that they, without board approval, that they don't stay beyond the term of the sublease. And again, as Richard mentioned earlier, important for owners, co-op owners and subtenants, and for a unit owner in a condo, to get insurance. You know, in a condominium, because it's real estate, it's homeowners insurance. In the co-op, both for the shareholder or a subtenant, it would be renter's insurance. And that should be in the operative documents, that that's a requirement, because it keeps the board out of a lot of these water damage issues and those kinds of things that come up with damages between apartments or something within the apartment. And that's something that should be in the documents and enforced. Rich, Neelam, anything I've missed?
No, it's
I think you did an awesome job. The
Yeah.
only thing is that came to my mind is when people sublet, or in the condo word, renters, the only thing that finances would be totally different, because they are paying a rent to the shareholder, and the shareholder is paying the maintenance.
Yes.
So we as board members, we have to just be more careful about their behaviors and how well they fit in the co-op cooperation. Is that right? Or is there any other factor that is missing that I'm not thinking of?
Well, I think you're right. I mean, the finances are important. You want to make sure that they seem like they can pay the rent, so that there's, you're hopefully not going to have a problem with arrears. But like we discussed, the shareholder is ultimately responsible for the maintenance, regardless of whether the tenant's paying him rent or not. So that's between them, because the co-op comes before the lender in who has priority here. So you have tremendous enforcement mechanisms if someone's not paying. So you're right. It's more about who's moving in, and you can say no, as long as you're not saying no for a discriminatory reason, that someone's part of a protected class, that's why you're saying no. But yeah, if you feel this, they're not going to fit in, or they're going to have late night parties or something like that, you can say no to that application.
Yeah.
We do have some questions in the chat box. I'll go to them now, if that's okay with Richard and Neelam.
Sure.
Question number 1. What is the recommendation for a board that wants to change either the length of the rental rule and or the amount of times it can be renewed? Right now, we have no limit on either.
Yeah, you have, I mean, from my perspective, and I'll also have the board members chime in, but from my perspective, I wouldn't say there's a hard and fast rule. It depends what's going on in the building. I mean, bigger buildings with more potential applicants might want to be more restrictive. Smaller buildings might be able to get away with, more frequency or longer terms. And it's just a feel for, what's going on in the building. I mean, to me, if I'm owning my apartment in a co-op, I sort of want to feel like my neighbors are also shareholder occupants and have the same stake in the building as I do. And at some point, if you're not going to be living there, maybe you should sell it to somebody who will.
As a follow-up, how do you deal with any long-term renters should you want to change the length of the time to be able to rent for?
Well, I'm not really aware of any co-op that allows a really long-term renter. In fact, a lot of buildings would say, even if you're doing a 2 or 3 year lease, we want to be able to revisit the application after, each year anniversary and say, yes, the second year's approved, the third year's approved. But I've never really seen anything beyond like a 3 year maximum. I mean, I don't know any buildings. None of my buildings do much longer, and I would discourage that, because you don't want to be stuck. If someone's a problem, who wants to deal with a long-term lease?
Our next question: how can a roommate be removed
From a co-op?
I'm assuming from a co-op. Yes.
Yeah, that's a good question. And actually, I hate, Ron, Scher, and I have had a lot of discussions with this, because whether that's an unauthorized occupancy, is it an illegal sublet? There's a lot of case law that's being developed about that. But if you want to say that person's not supposed to be there, you would, as the co-op's attorney, I would, try to bring an action that it's an unauthorized occupant. But you need to be looking at the operative documents and seeing what they say, because there's a few issues. Most proprietary leases will say, for example, that the shareholder, if they want to have other members of their family or other people live there, they have to live there as well, unless they're making a sublet application. So what happens if that shareholder moves out and, for example, leaves their child in the apartment or their parents in the apartment? Is that a sublet? Is that an unauthorized occupancy? The first department, which covers New York City, says yes, it is. That the word "and" means that the shareholder must be there with these other people. The second department, which covers Westchester County, has said that there's some confusion as to what that wording means. So it might be a little more difficult to get rid of a boyfriend or someone who's moved in with the shareholder who moves out, or even with the subtenant. So you got to speak to your attorney. You got to review the documents.
Next question. Who pays the maintenance on a sublet, the shareholder or the sublet?
The shareholder is still responsible for the payment of maintenance.
Our next question. If a proprietary lease prohibits subleasing, which legal steps can be taken against the shareholder?
If they're subletting?
Yes.
They're in violation of the proprietary lease. We would send them a notice to cure, saying you have 30 days or whatever the lease might say. Typically the lease will say that if someone is subletting without board consent, that's a default under the lease. We can send a notice to cure. If they don't cure, we can take steps to terminate their lease, and usually they wake up. Or if they have a lender, we can let the lender know what's going on and let them get involved. They can give their consent, presumably.
Okay, we have a few more. Give me a few seconds to scroll down a little bit.
Hey, Jeff, can I say something?
Please do.
The issue, Richard and Richard, is some boards try to limit subtenants' rights and say you can't have a pet, you can't smoke, you can't do this. That is potentially permissible, except subtenants and roommates even have the right to have an ESA or a service animal, and you basically have limited rights about it. I'll defer to you, Richard, on that. The rights.
Yeah, I mean, well, the whole pet policy thing is a very hot topic with a lot of my boards, and whether it's a shareholder or a subtenant, if they come in and want to, if they need a service dog or they need what's called an ESA, an emotional support animal, you can't say no. And what frustrates a lot of my boards is that they'll meet these people and there's no indication that they have a pet, that they want a pet. And then they move in 2 weeks later and there's a dog and they say, well, it's my emotional support animal. And they come up with a letter from some treating doctor. And it's tough, it's very, you have to move forward very carefully because you don't want to open your board to a claim of discrimination. But, there are something, especially with an emotional support animal, you can ask for a little more documentation and to clarify what's going on. But with a service animal, I mean, usually it's pretty obvious and, you have to allow it. So
it was one of my concerns that if the board tries to limit the rights of that subtenant, those people can supersede that. So Richard, very good point on you. And just so you know, paragraph 15 of all proprietary leases says you can't sublet without the consent. And Richard will go over, you can board set up sublet policies all the time based upon that.
Right, which is what we've been discussing. Yes, thanks, Ron.
Jeff, you're doing a great job as always, Jeff.
Thank you, Ron. Nami Kaur, you had a question? You can ask the question now if you'd like, Nami. You're on mute, Nami. If you could unmute yourself. Okay. You're still on mute, Nami.
Can't seem to unmute.
Here we go. Okay, you're on now, Ami. You're on.
Can you hear me now?
We're hearing you in fragments.
It took me a while to unmute, sorry. So
Okay.
I actually had more than one. Okay. I have two questions. One is, and Richard Klein, excellent presentation. I learned so
Thank
much
you.
from what you shared.
I appreciate that.
My
Thank you.
question is, first question is about the proprietary lease, and that is your recommendation. How specific should the wording be in the proprietary lease, like specifics about rules for subletting, or should it be a little more general to say that the board will define the rules and so give the control to the board in terms of the bylaws? Because the proprietary lease is a big deal. We have to get the shareholders approval, etc. So that's the first question. Let's go over that, and then I'll come back to the second one.
Sure. So, I recommend to my boards that you want to keep the language somewhat general. For example, if you want to impose a sublet fee, I would not say, oh, we're going to charge 1 month of maintenance. I would leave it general that, the board has the right to impose fees. The lease provision typically already provides that the board has the right to impose conditions. But, I keep it broad just so it's clear that the board has the right to come up with a sublet policy and also impose a sublet fee. And so typically that should be, usually that's enough. That should be sufficient without getting into the details. Although I will say sometimes it's hard to get the shareholders to vote on that because they feel it's too open-ended. They maybe want it specific. So you got to, tweak it and know who you're dealing with in your audience.
And Richard, second question, still related to the subletting by a co-op. So I'll just focus on that since I'm part of a co-op. In terms of the fees, we are actually considering that in my board, which is River Edge co-ops. And in fact, that's what kind of led to this presentation because we are looking at that, and I suggested the topic for our meeting today, and I'm glad it was a hard topic, so much interest in it. The question is, in terms of the fees, like, I think Rich mentioned they do a 1 month rent. Somebody else has mentioned they do a percentage, of the rent, or it probably comes to similar thing. Or should it be like a fixed amount? So there are many other fees we charge a subletter, like when somebody applies to actually sublet, they have basically application fees, blah, blah, blah. Then each year when we do renewal, we have year-to-year lease renewal. We pay certain fees, and of course the shareholder pays that fee. Okay, so my question is, what is your recommendation? That's why we're having this to hear from other people too. What are the benchmarking, rules, like what works, what doesn't work? Because there can be a lot of finagling with that. Somebody can kind of do a under rent, like, say, and so their percentage of subletting fee back to the corporation will be less. Should there be a flat fee regardless of what somebody's charging for rent?
Yeah, that's a good point. Obviously people can finagle a little bit if they want. Hopefully they're not, but I've seen, all types. Like Richard said, his board does 1 month of maintenance, not the sublet fee, but 1 month of maintenance, because we know what that is. It's some do a flat fee. Depends on what the activity is, what they're trying to accomplish in terms of the fees. Are they trying to, I don't know that you're going to build up your reserve tremendously on that. Although with some buildings, in the city, 1 month of maintenance can be somewhat significant. So I think it depends. I would say it's probably easier to do a flat fee or some calculation based on the maintenance because you know what that is. And you don't have to worry necessarily about what the sublet fee is and what they're putting down. So it's just probably easier to administer.
Yeah, the other thing to remember is in our building, we have different size apartments which pay different levels of maintenance. So you don't want to put it on one flat fee, say $5,000, and it's for a studio because that's not going to really go over very well. So it's 1 month of whatever that person is paying would go to the board. Makes it somewhat easier, and we could always change that if we needed to. Or and again, that fee is charged every year that the renter is renewed.
Richard, here's another question. Are there limits on the fees that can be charged for subletting?
I think there's been some litigation, at least in the city, about, some outrageous fees where it came out to some crazy numbers and the courts set that aside. I think, you got to be reasonable. I mean, like Richard just said, you don't want to charge 20, $8,000, $10,000, $20,000 to sublet, especially, it depends on, maybe on Park Avenue in the city, you can get away with a higher fee, but you have to know your building and what's reasonable. I would say be reasonable. Yeah. That's why I like Richard's use of, 1 month's maintenance. That seems like how can that not be reasonable?
Yeah, and it doesn't discriminate, oh, you charge
Right.
so this fee,
Exactly.
So.
All right, we're at 7:29. We have time probably for maybe one or two more questions. I'm looking at our questions here. Give me a few more moments, please. Okay. If the unit owner is the cause for property damages, for example, the owner causes a flood, are both the renter and the tenant liable for the damage costs?
I'm not sure I understand that question.
Yeah, I'm having a problem with that as well, Richard. Yeah.
I mean, if the unit owner or his or her tenant causes damage in the apartment, they should be putting in an insurance claim and get their coverage. And if they're coming after the co-op or the condo, I'm going to say, we're not responsible here. This was your fault. You deal with it, and that's why you have insurance. So, and if they, it depends what the damage is. If it's within their own apartment, that's one thing. If it goes, I have a situation where I live where someone left their sink on and had something in there, so it overflowed and it went down 4 stories. And there's all this damage and there's all this nonsense going on now. Hopefully everybody has insurance, but that apartment's going to be on the hook for all the damage that was caused.
Next question. Paragraph 15 of my PLA states the following. Any consent to subletting may be subject to such conditions as the directors or lessees, as the case may be, may impose. Would you consider that broad enough to cover the imposition of a sublet fee?
No, I would still want language in there about the fees, because it typically goes on to say, and they can charge, the administrative costs, or so there's some other language about what fees they can collect. So I would want it to be clear about the sublet fee.
Here's a general question. Is a live-in super's apartment a sublet?
Is a living super's apartment a sublet? No. I mean, the co-op typically owns that apartment and they're allowing their employee to live there, pursuant to his employment. And if he's terminated, he or she has to get out of the apartment. I don't consider that a sublet.
Right. I think we're at the end of our questions. I'm just scrolling down one more time.
Jeff, if you want, we can go through these questions. I'm happy to answer questions and then email you to distribute the answers, or directly email whoever it is, so that everyone's questions can be answered.
Richard, why don't you give them your email?
I'll let Jeff do that. Yes, Jeff, you have my contact info to give out. You can put it in the
chat.
Chat.
If anyone would like to ask Richard Klein questions, please contact me at jeff@buildersinstitute.org. That's Jeff, Jeff, at buildersinstitute.org. And I would be happy to send you Richard Klein's contact information. Well, at this point, I want to thank Richard Klein, Richard Filippi, and Neelam Khattri for their participation in tonight's membership meeting of the CCAC. I thought it was an excellent series of dialogues on a very important topic. And I thank all of you for tuning into Zoom to view what I thought, again, was an excellent summary on a very important topic. At this point, I will turn over the closing remarks to CCAC Chair Jane Curtis.
Thank you, Jeff. So I want to thank our presenters tonight. It was incredibly informative. And I think the questions that were asked are a great indicator of that. I hope all of you learned something this evening. I certainly did. You will be receiving a survey in your email inbox shortly. And please fill it out to let us know how we did. And also there will be an opportunity for you to suggest future topics. And this is of great interest to us because we're always looking to see what the trending questions and issues are so that we can organize our future general membership meetings. And with that, I will say good night to everyone, and please stay safe and warm in this weather.
One other note, please check buildersinstitute.org, our events link at buildersinstitute.org for future events of the CCAC and the BRI. That's buildersinstitute.org, our events link for future events of the CCAC and the BRI. And of course, meeting notices regarding those events will always be mailed to your individual email addresses. Once again, many thanks to Richard Klein, Richard Filippi, and Neelam Khattri, and CCAC Chair Jane Curtis for their participation in tonight's meeting. We wish you all a very, very good evening.